Family disputes can make us feel isolated and vulnerable. Maybe you're going through a divorce or a legal dispute about your kids. Perhaps you've spent hours on Google or have even posted anonymously on Facebook to see what others have to say. But are you getting the actual information and support that you're looking for? Our podcast, Legal Lounge, aims to dispel misinformation and downright bad legal information to empower anyone with questions about their family, their children, their finances, their marriage, and the law. As a team focused exclusively on family law matters, we aim to help listeners not only with the information they need, but also with the hope that their situation has a solution. Short disclaimer, please note this podcast is for educational purposes only, and the information should not be relied upon as legal advice or for legal purposes. Back on the Legal Lounge, and today we have Jaime Davis joining us. Jaime, tell us a little bit about yourself.
Well, I am a board certified family law specialist here in North Carolina. I am the co-managing partner at Gailor, Hunt, Davis, Taylor, and Gibbs in Raleigh. I've been practicing family law for almost 23 years now, and I love it.
That's awesome to hear. And just for our listeners to note, Jaime is from the Raleigh area, and that is a very different city than, say, Charlotte, where Modern Legal is based out of. So I'm so excited to get into today's topic, being how do attorneys work together or not when they're on opposing sides of cases? So Jaime, tell me a little bit about your experience when dealing with opposing attorneys.
Well, I think in most cases, it's going to vary, I guess, depending upon the county that you're in. But family lawyers tend to work pretty well together for the most part, I have found. And to the extent that they are able to do so, it's really beneficial to the client. When lawyers get along and trust each other, it can help facilitate a case, maybe bring a case closer to settlement. And, that could, at the end of the day, save the client some fees.
Yeah, that's a great point. And I'll come to your first point where family law attorneys, we generally know each other. Even though you're in Raleigh, I'm in Charlotte, I know of you. But even more specifically within our county or area counties, we're actually a pretty small groups. And it's common that if I have an opposing attorney, say in one case, I may actually have them as an opposing attorney in another ongoing case at the very same time. Does that ever happen to you?
Oh, all the time. I mean, the family law bar is not that big. And so I think it's really common that you run across the same group of folks, depending upon the cases that you're working on.
Yeah. And go one step further to your other point, where if you have a professional and good working relationship, that actually is beneficial and furthers a client's interest with their case.
Oh, definitely. I mean, I think sometimes clients can be a little off put if they think that you're being a little too nice to opposing counsel. And they're like, hey, are you guys friends? Like, are you on my side or not? And, you and I were chatting before the episode about how, yeah, we might be friends, but, our first duty is to our client. And so the client always comes first. But it can be helpful, I think, when lawyers get along. It can help further the case.
It's, especially here in Charlotte, it's known among our family law attorneys and bar which attorneys tend to litigate more often, which attorneys tend to negotiate more often. And at least from my perspective, because in family law cases, we can be more creative if we're able to negotiate and settle outside of court, simply because judges can't really get as creative as attorneys can. That if you know that an opposing attorney is willing to negotiate or go to mediation or utilize collaborative law, that we as advocates for our clients can often get better results for our clients because of that amicable relationship with an opposing attorney.
No, I agree with that 100%. I mean, I start off, I would say almost all of my cases trying to see if I'm going to be able to work it out and settle it for the client before we proceed with litigation. There are going to be exceptions to that rule, right? Like sometimes you really do need to file that lawsuit first, but for the most part, you don't necessarily need to do that. And once you find out who opposing counsel is, you can kind of, do the cost benefit of, okay, if I reach out to them and ask them, are they willing to voluntarily exchange some financial documents? Can we get our clients into mediation? Whether or not they're going to be inclined to do that, or whether or not that effort is going to be fruitless. But I will say more often than not, I will say that it is worth it to try that first.
Yeah, well, and it's because as practicing attorneys for a notable amount of time, we know the processes, right? We know that if a family law case goes all the way through, and regardless of the matter, regardless if it's just child support or it's a full case that involves divorce, alimony, equitable distribution, which refers to the distribution of debts and property, that you're going to have to disclose those financial documents at some point. Just
Right.
because it's not tomorrow or next week does not mean that you can hold on to those documents and keep them private, because even if you don't want anyone to see them, they will come out because they'll be court ordered to come out if you don't turn them over at some point. And it's either do we do so voluntarily, like you were just pointing out that we could do a voluntary document production, or are the attorneys going to have to utilize the litigation tools such as discovery, a request for production of documents, all these other tools that we do have in our toolbox as family law litigators, but honestly take a lot more time, take a lot more effort and money out of our clients' pockets, that often they're already financially strapped because they're going through a family law dispute to begin with.
Yeah, when I have a client who does not want to provide their financials, I say, well, we can do it the easy way or the hard way. The easy way is that we voluntarily exchange with opposing counsel. And the hard way is that they're going to file a lawsuit against you and you're going to have to produce those documents anyway. So, really, it's up to the client which way they want to do it. But it can certainly be a more productive use of everyone's time and their hard earned money to do it the easy way.
Exactly. I completely agree. I feel like the same sentiment is shared in our community over here. And go one step further, there are options outside of litigation, such as a voluntary mediation, where parties can attend, I mean, even before they separate, really, that help parties resolve issues while they're still living together or right after they have moved out from each other's residence. But if that does not come up, then the court may order a mediation or a settlement negotiation session. And here in North Carolina, it's specifically required for child custody, as well as at least in Charlotte, we do mediations for equitable distribution as well.
I find that I mediate probably in the vast majority of my cases, either voluntarily or because it is court ordered. And I find that mediation is a really helpful tool, especially in family law cases, to help folks get these issues resolved, especially when it comes to custody. I find that the two parents are the people in the best position to make decisions about what's in the best interest of their child. And they may not see eye to eye, right? Because emotions are running high when folks get separated and they're scared and they're anxious about what's going to happen and who their child is going to live with and when.
I completely agree. And noting back on the document production, if you go to mediation prepared, and if I specifically know the opposing attorney is going to come to the mediation prepared, then I know that we have a much better chance of not only pursuing an amicable resolution, but more importantly, attempting to get the parties to that sweet spot, if you will, where both parties are comfortable and they're okay with the resolution versus going to a courtroom. And I see it time and time again where, especially if an opposing attorney is particularly litigious, we'll just send everything to the courtroom. And yes, we can litigate, right? Family law, we do litigate a lot. But then a judge determines the outcome, not the opposing attorney, not the opposing party, not my client, not you or me, right? It is the
Right.
judge. And I mean, I was just in trial where the judge, I actually have thought about him a lot, poor thing, because I don't think he ever did family law before he got on the bench. And he's been on the bench only a couple of months, being thrown all of these complex family law matters and being litigated by pretty aggressive litigators. And personally, I would not want any judge, including this one, to decide the fate of my children, the fate of my finances, and the fate of what happens to our property and debts.
Judges just simply don't have enough court time to learn all the ins and outs of a particular case, whereas the lawyer has represented the client for usually a significant period of time, knows all about them, knows all about their family, their children, the dynamics, their finances, all of the things. And so if the lawyer can work with the client to get the case resolved prior to court, that's going to be beneficial to the client. And I think that it is an added benefit if the lawyer has a good working relationship with opposing counsel. One thing we haven't really talked about yet is that there are certain professional courtesies that we as attorneys extend to other attorneys and opposing counsel. For example, there are lots of deadlines in family law cases, and sometimes for whatever reason, life happens and we can't meet those deadlines, and we've already gotten our formal extension through the court. But it's not uncommon for one lawyer to reach out to the other and say, "Hey, I know my client's ED affidavit is due on Friday. Would you mind giving me an extra week?" And more times than not, the other lawyer is going to say, "Absolutely, that's fine," because they know if they need an extension in the future of a few days or so, that you're probably going to give them one. Likewise, it's not uncommon for cases that are in litigation for one side to offer to answer the calendar call before the hearing for both attorneys. There's no need for both lawyers most times to show up and for their clients to incur fees for them both to answer, especially if the case has been settled and all the attorneys are doing is showing up to report the matter settled and to get the formal documents entered. So that's another courtesy that can help move a case along and help save fees. What are some that you have run across, Theresa?
I would say specifically here in Mecklenburg County or Charlotte, if there's a good working relationship, we often can resolve cases way ahead of any court process. And I've seen it, and I'm talking full cases where there may be domestic violence, there may be other factors that influence the property distribution, such as someone owning a business. And it's not unheard of where divorce can take not only months, but years, especially if it takes 3 to 6 months just to get a custody evaluation, a parental fitness evaluation, or a business valuation. I mean, often business valuations can take even longer than 6 months just because of all the documents they may need to go through. And so, if we're able to have that amicable discussion prior to any lawsuit being filed and actually go into the details in those documents, I mean, I've had cases resolve themselves within 2 to 3 months, maybe 4 months, even complex cases, because we can all get an idea of what the value of that business is or what the child may need because we've all agreed for a child to see a therapist. And the sooner that happens, I feel everyone tends to feel better about the outcome, even if the outcome is, yes, parties are moving forward with divorce or parties are moving with a separated situation where they're sharing time with their child in different residences. But no one, it's interesting because I don't think anyone can really put a value on a quick court process or legal process, I should say, as compared to going through the whole court process and litigation process, not unless you've gone through it. And I have had many clients who have had to litigate every single issue a year, 2, 3, 4 years later. Basically, what happens is what I told them would likely happen on, day one,
Right.
and they've incurred the not only legal expenses, which is a whole nother topic that we could spend a whole episode on. But I would say more importantly, the fact that you're caught up in this, division of a relationship that, yes, you already spent however long the marriage was, but now you're spending years on dividing it.
Talk
Right.
about the emotional and mental toll of that.
That is obviously going to spill over into the co-parenting relationship as well, right? Like if there are kids and you're still enmeshed in this very high conflict litigation, maybe it's not even about the children, maybe it's about the finances, but the conflict is still there. And, it's impossible, no matter how great of a co-parent you are, that is not going to impact you in some way, whether it's you're distracted because you're thinking about the litigation. Maybe it's taking up your time because you're having to meet with your lawyer and prepare for court and get documents together. Or maybe just deep down, you're really still mad at your ex spouse because you're still involved in this lawsuit. And, it's going to come out in some way. So, yeah, I mean, getting it resolved without going to court and spending the years and the potentially hundreds of thousands of dollars to get there, it's definitely the way to go. And I wanted to go back to something you said a minute ago about business valuations. That's another great place where if lawyers know each other and get along, they may be able to agree on one person, one business valuator to do the valuation for both of you, which is going to save substantial fees in terms of what you're going to have to pay that expert. So if the lawyers can agree on who that expert will be to value the business and you guys can pick one, that's another way to get some cost savings as well.
That's a great point because I've had that happen more than once.
There's no conversation more romantic than discussing a prenup with your partner, right? Okay, maybe the song for your first dance does a bit more in the romance department. Speaking of emotions, though, the prenup is a very legal document that everyone has a very emotional reaction to. Many people avoid the prenup conversation because they feel it is an indication that the marriage will fail. But here's the truth. Half of all marriages already fail, regardless of whether the spouses had the prenup conversation or not. If you or someone you care about is getting married, would knowing what marriage involves legally be important? What about having the difficult conversations surrounding finances, career aspirations, and pursuing parenthood prior to the wedding date? If you are looking to build a solid foundation for your marriage, or you want the same for someone you care about, we are here to help you learn more about prenups from a position of knowledge, not emotion. To learn more about family law from a legal professional, book a consultation with a member of the Modern Legal team by visiting our website, emailing us, or calling us at 704-286-6302. Check out the information about Modern Legal services at modernlegalnc.com.
Every attorney approaches a case in a very unique fashion. And that's part of the reason we can never tell our clients how long this will last, how much it will cost. And on the flip side, when I am talking, especially with a prospective client about their case, I will often ask the question, okay, who is the opposing attorney? Has the opposing party hired anyone yet? Because I do know some attorneys in town where if there is a business valuation issue or need, I'm going to know, oh yeah, that attorney is going to want their own business valuator if we go to trial. So maybe we try some other tactics before we have to file a lawsuit. On the flip side, if you are able to agree to one business valuator, it saves time, effort, so many things. Not only the mental and emotional toll on clients, but it helps our toll as well, right? Because we are humans. I think sometimes our clients forget that, but it helps us too. And if we're talking about a property distribution where really we're just trying to figure out the final numbers until we can do the 50-50 division, then that can not only save on not having to file a lawsuit, but also that mental and emotional health as well.
Do you ever have clients say to you, I want you to be really mean to opposing counsel?
Oh, I love those. And actually, I do, because I do love sending a good nasty letter. I think it's kind of therapeutic for me. And it's never directed at anyone personally, though. It's all about the legal strategy behind our demands. So, for example, I don't know how often you use this tactic, but we do have the heart balm torts here in North Carolina. So, alienation, affection, and criminal conversation. And every once in a while, yes, we'll have to file one of those lawsuits. But more often than not, if I send a threatening letter saying, hey, we're going to sue the paramour for X, Y, Z, the opposing attorney knows, oh, okay, Theresa, I know this is one of your nasty letters. We all know how common these lawsuits actually are. Okay, we're willing to negotiate. not because they're necessarily taking my letter as a joke, but more so to know that, hey, we have the evidence that we need to pursue that type of claim. So instead of trying to throw everything at each other and start mudslinging, let's actually talk, because there's mud that could be slung, but talking would be a lot more beneficial in this circumstance.
Well, so I think you raised a great point. So I don't know that I would even call a letter like the one you're describing a nasty letter. I think that's you doing your job and, you know, portraying your client's case to the other side in a way to help them, right? I think
Mhm.
that as lawyers, what's important is to remain professional with opposing counsel. And if the facts and law are on your side, that's one thing. But, it's the resorting to personal attacks where the
Mhm.
lawyer tries to personally attack the other lawyer that, that's really not necessary, right? Like we're just people doing jobs just like everybody else. And our job is to zealously advocate for our client, but not necessarily to bring down opposing counsel in the process.
Especially because that opposing counsel will likely still have their job after this case.
Right. Good point.
And we don't need to ruin our relationship or ruin and threaten our licensure or practice as well. What do you do in instances where you know that the opposing attorney is one of the more difficult opposing attorneys?
I don't change anything about how I practice or how I would handle the case. I just do what I was going to do anyway. And to the extent I can, I try not to engage with the other lawyer. What that does for the client, though, is that means more of the formal processes are likely to be
Mhm.
used, more of the formal court processes, where it really is a waste of everybody's time, money, and frankly, breath to try to have a conversation with the other lawyer, a reasonable conversation about getting the case settled. And so in those cases, a lot of the times the judge maybe does have to make the decision, right? Because you don't have another choice. But I always take the high road. I tell my clients I always take the high road. I certainly do not get down and sling the mud with opposing counsel if that's how they want to practice. What about you? How do you handle those situations?
I would say it's similar. I think for me, it's if they're a very litigious opposing counsel, I may tell my client, I know about this attorney. If I send a settlement letter today, I don't predict that they'll respond. We still generally send out at least one settlement letter at some point. But if they don't respond, I'm not here telling my client, okay, let's send another one and we'll follow up. And suddenly 2, 3, 4 months passes by when we haven't gotten a response. Go one step further. I know some attorneys will want us or on my side to file that motion to compel documents because they're not willing to turn over anything. And so I prepare my client for that reality that they're not going to settle or they're not going to turn over the documents voluntarily. So we may need to get a little bit more aggressive and file that motion to compel, or if they violate an order compelling documents, maybe a motion for contempt, which yes is punishable with incarceration at times. And I say that more so in the sense of getting more aggressive with the tools in our toolbox, not as a personal attack to the opposing attorney or opposing side, but more so because we have a job to do. And that
Right.
job does include getting documents, and that job does include getting a resolution, hopefully in the next year, not in the next 5 years. And so that's how I kind of handle it differently, and making sure my clients are aware that yes, they may want to negotiate out of court, but if the opposing side and the opposing attorney aren't willing to show up to that negotiation session, let's not even schedule it.
Yeah, that's exactly what I meant when I said that, the client may need to be prepared, that we're going to have to use more of those formal court processes with filing the motions and really just going through all of the legal steps to get the things that we need to advocate for our clients.
And that's a great point because I know a lot of people may start their case as a pro se party, meaning representing themselves, and they tend to not know all the tools that are there.
Right.
And if a person goes into a family law matter and they don't have an attorney, but the opposing side has an attorney, that attorney will seem extremely mean. That attorney may seem aggressive as well because they're using all the tools that you and I know about, but pro se parties don't know about. And so I've had that question come up, especially during consultations with prospective clients. because they feel like they've been beaten up on. And I understand it, especially if this is an area that you just don't know. You've never been in court. You've never had a traffic ticket, let alone a claim in family law filed against you. It seems very aggressive, but this is our world. And so I like to say to my prospective clients, I'm like, well, if I were that attorney, I'd probably be doing the same thing. On the flip side, once you hire an attorney, trust me, we can match them with the same tools, the same tactics.
Absolutely.
Well, I don't want to take too much of your time, but I truly appreciate you joining me today, Jaime, on the Legal Lounge, and we hope to have you back again soon.
Thank you so much, Theresa. I've really enjoyed our conversation today.
Thank you.
Thank you for taking the time to listen to our discussion. To learn more about me and the Modern Legal team, go to our website, modernlegalnc.com, or check out the links in our show notes to follow us on Instagram, Facebook, LinkedIn, and YouTube. You can also call us at 704-286-6302. If you have been intrigued by the conversation and would like us to continue our discussions, please subscribe to the podcast and leave us a review. See you next time.